Hi, I'm California probate attorney Scott Grossman. In this video, I'm discussing how to keep your California executor honest during the probate process without getting disinherited. In this video, I'll be discussing whether you can be disinherited for holding the executor accountable. I'll also be discussing how you can get financial information from the executor and how to deal with an executor who isn't doing their job to bring the probate estate to a close. After watching this video, you'll know the two most common ways of keeping your executor on track and getting full disclosure through the process. It's not uncommon for beneficiaries who are upset with an executor to get told by that executor that if they do anything at all, they're going to be disinherited. Well, that's flat wrong. That's simply not the law in California. The only way you can get disinherited is if you file a will contest and lose. For many beneficiaries, the real issue is they're unhappy with the way the executor is carrying out the terms of the will. That's the exact opposite of a will contest. If what you're doing is enforcing your rights under a will, you're not going to be disinherited. This situation often comes up in two different ways. The first is probate administration has been going on for over a year and the beneficiaries haven't received any meaningful financial information. Well, if that's your situation, then the way to address this is to file a petition with the probate court to instruct the executor to account. I could tell you that after a year of administration with no meaningful financial disclosure, there's a high probability the court is going to grant that petition. Some executors who receive this petition think that this is going to lead to disinheritance, and they think that they're the ones who get to decide whether or not disinheritance occurs. Well, they're wrong. That's not the way that California law works. If you file a petition for instructions, that is not going to lead to disinheritance. The second situation in which this comes up is where an executor isn't taking the actions that are necessary to bring an estate to close. Now, this can happen lots of different ways, but probably the most common is where there's a piece of real estate that's going unsold. It may be that your executor is living in it, they may have a family member living in it, or the executor may just be plain lazy and they haven't gotten anything done. Whatever the reason is, the way you address it is the same. You file a petition for instructions with the court or a petition to remove the executor. Now, if it's a petition for instructions, then what you're asking the court to do is to actually direct the executor to carry out a particular action, like the sale of real estate. If the estate really is stalled, you can expect that this petition is going to be granted because there is no probate court that wants a petition remaining open for no good reason. Some executors take the filing of a petition for instructions or a petition for removal as a challenge to their authority. It is. It's also to your benefit, and California law provides for it, so you're not going to be disinherited. If you're looking for a full step-by-step guide to California probate litigation, or trust litigation, or you just want to know what to expect and how to prepare for your case, then please view one of the playlists on the channel. If you found this video helpful, then please hit the subscribe bell, leave us a comment. We'll be glad to respond if you do, and give us a thumbs up.